Good evening and welcome to Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. The Supreme Court has suggested excluding farmers burning their stubble from the purview of minimum support price infrastructure as a part of carrot and stick policy to disincentivize stubble burning in Punjab and other states adjacent to Delhi. A bench of Justices Sanjay Kishan Kaul and Sudhanshu Dhulia was hearing a batch of pleas raising concerns over the deteriorating air quality in the Delhi NCR. As you know, the region typically faces heightened pollution during the winter months, largely due to factors such as stubble burning in the neighbouring states. The court noted the report filed by State of Punjab, which suggested that 8,400 meetings had been held with farmers and farm leaders to convince them to not burn paddy straws by station house officers. There are 1,092 flying squads constituted. However, the upward trend in farm fires has not abated. 984 FIRs have been lodged and registered against landowners. The court pointed to the disparity in the land holding sizes to explain that larger farmers profited by selling bales made out of stubble through a mechanized process, while smaller farmers found it difficult to make the initial capital investment of buying baling machines. It then recommended completely subsidizing baling machines for poor farmers and financing their operating costs to convert stubble into a useful byproduct that could be sold for a profit by the state government. The Supreme Court today reprimanded the Patanjali Ayurved for continuing to publish misleading claims and advertisements against modern systems of medicine. The bench, comprising Justices Asanuddin Amanullah and Prashant Kumar Mishra, was considering a petition filed by the Indian Medical Association, that is the IMA, against misleading advertisements. The petition asserts that Patanjali's misleading advertisements downgrade allopathy and make false claims without curing certain diseases. The IMA contends that while every commercial entity has the right to promote its products, the unverified claims made by Patanjali are in direct violation of laws. The bench observed during the hearing that it did not wish to make the issue an allopathy versus Ayurveda debate, but wanted to find a real solution to the problem of misleading medical advertisements. The government was asked to come up with suitable recommendations after consultations. The court issued a stern warning to Patanjali, the company co-founded by Baba Ramdev. It directed that it shall not publish any such advertisements in the future and would also ensure that casual statements are not made in the press. The matter will be considered next on 5th February next year. The Supreme Court bench, comprising Justices Sanjay Kishan Kaul and Sudhanshu Dhulia, today heard an application filed by National Capital Region Transport Corporation highlighting the breach of undertaking by the Delhi government regarding contribution towards the RRTS project. In July this year, the Apex Court was informed that the Delhi government was not making a contribution towards the regional rapid transit system due to budgetary constraints and had directed the government to file an affidavit disclosing the funds used for advertisements in the last 3 financial years. Post this, the government undertook before the court that it will make budgetary provisions for the project. Today, the court pulled up the Delhi government for gross breach of the assurances given. The bench also underlined the importance of the project by saying that it has an impact on reducing pollution, and that the budgetary allocation for the advertisements for the last 3 years was almost 1,100 crores and for this financial year is around 550 crores. Expressing great disappointment with the stand of the government, the court passed an order to transfer the advertisement funds of the government for the project. However, the court kept the order in abeyance for 1 week at the request of the counsel for the government, stating that the order would come into operation if the government did not voluntarily transfer the funds within a week. In another update, the Supreme Court has held the procedure adopted by Himachal Pradesh Public Service Commission and the High Court in selection of civil judge junior divisions in 2013 to be wrong, and consequently the appointments of 2 judicial officers to be irregular. A bench comprising Justices C.T. Ravi Kumar and Sudhanshu Dholia was hearing the appeals filed against a 2021 judgment of the Himachal Pradesh High Court, which set aside the appointments of the 2 appellants as civil judge. The High Court, on its judicial side, found the appointment of the appellants to be illegal as they were made over and above the advertised vacancies. Although the Supreme Court agreed with the High Court on the point of law, it found the High Court to have erred in quashing the appointments. The court refused to unseat the 2 officers, considering the fact that they have rendered over 10 years' service and that there was no fault on their part in the irregularities. The Apex Court placed reliance on the recent Constitution Bench judgment in Sivanandan CT and others versus High Court of Kerala, where it refused to unseat certain district judges in Kerala despite finding their appointments to be illegal in view of the fact that they had been rendering service for 6 years. In another update, the Supreme Court has dismissed the appellant's plea for bail on grounds of parity with other co-accused who had been granted bail in a money laundering case. The court empathetically stated that the principle of parity is not an absolute law but depends on individual circumstances and roles in the alleged offence. The Supreme Court bench, comprising Justice Aniruddha Bose and Bela Trivedi, was hearing an appeal against the Delhi High Court judgment, which had rejected the bail application of the petitioner. The petitioner was charged with offences under Prevention of Corruption Act and Indian Penal Code. The appellant, nephew of Keval Krishan Kumar, one of the directors of Shakti Bhog Foods Limited, that is SBFL, was arrested in June 2022 in connection with a money laundering case. In the present case, he argued that since other co-accused in similar situations have been granted bail, he should also be entitled to the same. However, the court firmly rejected this argument, emphasizing that the application of the principle of parity requires a careful consideration of the specific role played by the accused under consideration. In this case, the High Court had distinguished the appellant's situation from that of other individual, Raman Bhararia, who had been granted bail. The court noted that while Bhararia was an internal auditor of the company for a brief period, the appellant served as the vice president of purchases responsible for day-to-day operations. The High Court further observed that the appellant's role was evident from financial records indicating the diversion of loan funds to sister concerns where the appellant held a stake. The Apex Court rejected a blanket application of the principle of parity and dismissed the appeal. The Supreme Court has held that the police have to obtain a transit remand when arresting an individual outside the jurisdiction where the offence is registered. This mandate is in line with the requirements of Article 22 of the Constitution, emphasizing the need for police to facilitate the accused's transfer from the location of arrest to the jurisdiction where the crime is registered. To understand this, imagine you are arrested in one state, but the police need to take you to another state where an FIR is registered against you for further investigation. That's where transit remand steps in. It's like getting a permission slip from a judicial magistrate, allowing the police to move you to another state while keeping you in their custody. The Supreme Court bench, comprising Justices B.V. Nagaratna and Justice Ujjal Bhuyan, was hearing an SLP against the judgment of Sessions Judge Bangalore, which had allowed extraterritorial bail petition by the accused husband. Aggrieved by the same, the petitioner had approached the Apex Court in an SLP. In this important judgment, the bench has also held that the Sessions Court or High Court do have the power to grant interim or transit anticipatory bail when the FIR is not registered within the territory of a particular state but in a different state. To read about this in detail, do visit livelaw.in. The additional District Consumer Disputes Redressal Commission Belagavi bench in Karnataka has held Xiaomi India's MI customer head office and grievance officer along with the dealer liable for selling a defective television to the complainant. In this case, the complainant purchased an MI LED television from Infinity Retail Limited Trading, that is the dealer. Subsequently, he faced operational issues with the television which displayed errors on the screen. The complainant initiated a complaint with the dealer and the dealer sent a technician to repair the TV. The technician found a defect with the remote control and assured to check the same. However, the technician failed to operate the television properly. The complainant then lodged a second complaint with the dealer. However, no resolution was reached. In the third instance, the complainant's grievance was intimated to the MI Consumer Head Office and Grievance Officer of Xiaomi Technology India Private Limited, that is the manufacturer, for approval, but neither responded or complied with the demand. Feeling aggrieved, the complainant filed a consumer complaint. The dealer contended that it was not responsible for manufacturing defects as it only sold the product and any issues should be addressed by the manufacturer. But the District Commission held that the dealer was a party involved in the transaction and had a responsibility to ensure that the product sold was free from defects. Further, the District Commission noted ignorance of legal notice sent by the complainant to the dealer and the manufacturer indicated a lack of willingness on their part to resolve the matter through amicable means. The Commission directed the dealer and the manufacturer to replace the television within 45 days and in case of failure to do so, to refund the invoice price with interest. Additionally, the Commission directed them to pay compensation of 5,000 rupees to the complainant for the deficiency in service and rupees 3,000 for the litigation cost. And lastly, the Delhi High Court has directed the Union Government to undertake an exercise for improvement of infrastructure of the hospitals being controlled and run by it in the national capital. The court was hearing a suo motu PIL initiated in 2017 concerning the issue of safety and security of medical specialists in public hospitals, violence being faced by them, and the lack of sufficient experts to provide healthcare in the hospitals. The court had actually taken suo motu cognizance of a newspaper report published by the Times of India in May 2017 titled "Aims Doctors to Get Self-Defense Training." During the hearing, amicus curiae senior advocate Siddharth Agarwal submitted that the matter not only concerns the broad issue of safety of doctors, but a 360-degree view has to be taken regarding the entire mechanism of healthcare delivery system, especially in government hospitals. A division bench of Acting Chief Justice Manmohan and Justice Mini Pushkarna directed the Delhi government to file an action-taken report stating as to whether the recommendations of the expert committee, which was constituted to enhance operational standards and treatment methodologies within government hospitals, are being implemented or not. Thank you. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.